the labor movement in this country has paved the way for dozens of protections for both union and non-union workforce, including the 40-hour work week, paid vacation, sick leave, pensions, health insurance, and the list goes on. Thomas Donahue, one of the most influential labor leaders, said, "The only effective answer to organized greed is organized labor." This couldn't be truer today. The forces of greed are hard at work to undermine all of the gains made in the past 150 years. On the eve of Labor Day weekend, President Trump decided to block the wage increases for all civilian federal workers, which will hopefully be overruled by Congress in the next spending bill. Today, we examine the influence and impact of the Supreme Court on the rights of workers. Professor Arthur Leonard is a Robert F. Wagner Professor of Labor and Employment Law at New York Law School. He's been a member of the faculty since 1982 and the founder and the first president of the LGBT Bar Association of Greater New York. Professor Leonard was born in Brooklyn, educated at Cornell. He is the editor of the LGBT Law Notes since 1980 and a contributing editor for Gay City News. Please welcome Professor Arthur Leonard.
Good morning, and happy Labor Day weekend. I'm gratified that so many people came out on a holiday weekend. In preparing for my talk, I originally said I wanted to talk about two Supreme Court decisions from last year, but I realize now that talking about both of them would probably take more time than has been allotted for this talk, so I'm going to focus on one of them, and depending upon the time that's left, I may say a little about the other. So my focus is going to be a decision announced on May 21st by the Supreme Court, Epic Systems versus Lewis. And I may get also to discuss Janus versus American Federation of State, County, and Municipal Employees, which was decided on the last day of the court's term, June 27th. Labor Day is a federal legal holiday in the United States, first designated by Congress to take place on the first Monday in September. And the first official federal Labor Day was observed in 1894. It was specifically intended to honor the American labor union movement, which is a bit ironic, historically speaking, because at the time the movement had very little legal protection or status and was relatively small, concentrated in a few industries and a few parts of the country. And just a few years earlier, with the passage of the Sherman Antitrust Act, the federal government had given employers a powerful tool to combat union activity, perhaps inadvertently, because the Sherman Act was really intended to deal with monopolies in business. But it said that any combination or conspiracy and restraint of trade was a violation of federal law, and it authorized federal courts to issue injunctions against such activities. Employers quickly persuaded federal courts that any concerted activity by employees to withhold their labor, to engage in strikes or picketing or boycotts, was a combination or conspiracy in restraint of trade, an attempt to monopolize the labor market. And courts issued injunctions in labor disputes. And for violating those injunctions, labor leaders went to jail or were fined. This was the legal landscape in the 1890s for organized labor in this country. And in fact, even under common law, that is non-statutory principles, courts had been issuing injunctions against concerted activity by workers for almost a century by that time. They were seen as a conspiracy to inflict economic injury on the employer. The federal government didn't switch over to support for labor unions until the 1920s with the passage of the Railway Labor Act and the establishment of a federal agency to deal with disputes on the railroads. That law was amended in the 1930s to extend to the airlines. More significantly, in 1932, a historic date in the history of American labor, Congress passed the Norris-LaGuardia Act, co-sponsored by Senator George Norris and then member of the House of Representatives, Fiorello LaGuardia, who went on more famously to be the mayor of New York City. The policy declaration in that statute is very important, partly because the language that Congress used was reused again in later statutes and is very relevant to the issue decided in the case that I'm going to talk about. Congress said Whereas the individual unorganized worker is commonly helpless to exercise actual liberty of contract and to protect his freedom of labor, it is necessary that he have full freedom of association, self-organization, and designation of representatives of his own choosing, and that he shall be free from the interference, restraint, or coercion of employers in the designation of such representatives, or in self-organization, or in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. So Congress declared as a policy of the United States government that workers be free to form labor organizations, to support them, to pursue collective bargaining with their employers, and even outside the context of labor organizations, to engage in concerted activity for mutual aid or protection. The Norris LaGuardia Act sharply restricted the power of federal courts to issue injunctions in labor disputes, intending to put an end to the use of the antitrust laws against union activity. The act also prohibited federal courts from enforcing what were called yellow dog contracts. These were agreements that employers required employees to sign as a condition of employment, stating that they were not a member of a labor union, or if they were, they would promptly quit, and that they would not engage in any union activities. So if you wanted that job, you had to sign an agreement that you would have nothing to do with unions. And those had been enforced by federal courts, as well as state courts. This statute specifically prohibited federal courts from enforcing such agreements. So the Norris LaGuardia Act endorsed the view that individual employees under our free system should have the liberty of association to form unions and to require employers to bargain with them. But the statute didn't really establish any sort of federal administrative framework to enforce these rights. It was really aimed primarily at stopping federal courts from issuing injunctions against concerted activity. When the Roosevelt administration came in, shortly after the Norris LaGuardia Act was passed, Franklin Roosevelt was elected in 1932 and took office in March of 1933. We were at the depths of the Great Depression. Estimates were from a quarter to a third of the civilian workforce was unemployed, and the union movement was at a very low ebb. One of the New Deal statutes passed to try to combat the Depression was the National Industrial Recovery Act, which, among other things, declared as a federal right the right of workers to form and join unions, and established an agency called the National Labor Board to enforce this right. But the provisions were very weak, and in fact the statute itself was declared unconstitutional by the Supreme Court a few years later, basically because of the very narrow view that the justices took of the power of Congress to regulate commercial activity in the states. But Senator Robert Wagner of New York, a graduate of the school at which I teach, New York Law School, was determined to salvage the labor provisions of the National Industrial Recovery Act and strengthen them. And so he sponsored in Congress the National Labor Relations Act, which is commonly referred to by practitioners of labor law as the Wagner Act, and it passed in 1935. And it set loose a wave of union organization in the country as the economy was reviving with the efforts of the New Deal. Unions organized in the coal mines, in the steel mills, in the auto plants, many areas of the economy that had previously not been affected to any great degree by union organization. And the National Labor Relations Act took the language from the Norris LaGuardia Act, and which had also been used, in fact, in the National Industrial Recovery Act, and put it at the heart of the National Labor Relations Act, that employees have a right, among other things, to join and form unions, to engage in collective bargaining, and in other concerted activity for mutual aid or protection. And concerted activity, of course, means activity on behalf of a group, not just an individual. But this statute went a step further. It included a list of what were called employer unfair labor practices, and it established a new agency, the National Labor Relations Board, which was charged, among other things, with preventing unfair labor practices by accepting complaints against employers, by being authorized to issue orders against employers and going to court to get those orders enforced if the employers didn't voluntarily comply. And the first section, the first listed unfair labor practice under Section 8.1 of the Wagner Act, took language verbatim out of the Norris LaGuardia Act and said it's an unfair labor practice for an employer to interfere with or coerce employees in the exercise of what they refer to as the Section 7 rights. And that refers back to the provision that says that employees can engage in concerted activity for mutual aid or protection. It also made it an unfair labor practice for employers to refuse to bargain collectively with the union selected by their employees, and it gave the NLRB a framework for supervising elections in which employees by secret ballot could indicate whether they wanted a union to represent them. Okay, so this statute went into effect, and under this statute, and with the impetus of the revival of the economy under the New Deal, and especially as World War II got started, which put a real burst into the economy with stepped up government spending, the union movement made great strides, and the National Labor Relations Board under the Wagner Act was there to back them up by enforcing the unfair labor practice provisions. But with the outbreak of the war, there was a real concern about any interruption in production during wartime, strikes, work stoppages. And so Congress authorized the establishment of the War Labor Board, and with the requirement that unions agree no strikes or work stoppages for the duration of the war. So how are they to resolve disputes? If they couldn't be dissolved through negotiations, and if unions couldn't strike, arbitration emerged as the answer. The War Labor Board recruited and trained a corps of arbitrators who were sent out around the country to settle disputes peacefully. And the parties would agree, whatever the arbitrator decided, that would be it. Whether it was a question of interpretation of any collective agreement they had, or any grievance about pay or promotions or things, union discipline or discharges or things of that sort. So arbitration became embedded as part of the relationship between unions and employers under the aegis of the War Labor Board during World War II. At the end of the war, the no strike pledge was dissolved. 1946 was the biggest strike year in US history at that time, with all this pent-up demand for wage increases and benefits and things of that sort. And in 1946, in the midterm elections, Democratic majority in Congress gave way to a Republican majority in Congress, and the Republican majority said the Wagner Act is biased against employers. It is a totally pro-employee statute. The board, National Labor Relations Board, is too pro-employee and pro-union. We need a balance. And so they passed what was known as the Taft-Hartley Act. And the Taft-Hartley Act was intended to rebalance the National Labor Relations Act and make it even-handed. So among other things, it said employees have a right to refrain from engaging in concerted activity if they don't want to, and that they don't have to join a union if they don't want to, although they did allow unions and employers to negotiate a provision in their contract that people, if the union was representing them, would have to join the union. But only after a union had been chosen, because the union, once it was chosen, had a duty under the statute to represent everybody in the unit. So they said everyone should be a member and contribute. In the 1950s, the Supreme Court modified that. They said people who don't want to be a member don't have to be a member, but they still have to pay dues. But their dues can be discounted so that they're not forced to subsidize political activity by the union. It should only be to cover collective bargaining and administration of the collective bargaining agreement. That's a Supreme Court decision involving the General Motors Company from the 1950s. But getting back to that period in the 1940s, they added to the statute union unfair labor practices, things that unions were not supposed to do. It mainly involved boycotting and picketing in certain circumstances. And they also added a provision for the first time providing that the collective bargaining agreements made between unions and companies would be enforceable in federal court as a matter of federal law. It would be part of what is called the federal question jurisdiction of the federal courts. Now, one of the developments in collective bargaining was that after the experience with the War Labor Board and the arbitrators, unions and companies saw that arbitration could be a good way to resolve disputes during the term of a collective bargaining agreement. So they generally included in their collective bargaining agreement a grievance procedure that would culminate in binding arbitration if the parties couldn't settle their disputes through negotiation. And of course, since collective bargaining agreements under Section 301 of the Taft-Hartley Act became legally enforceable, that created an exception to the ban on federal courts issuing injunctions in labor disputes under the Norris-LaGuardia Act back from 1932. All of a sudden now there was a specific authorization for courts to enforce collective bargaining agreements, including their arbitration provisions. So it became standard practice in American industry, in at least unionized industries, that all disputes would go to arbitration. And the Supreme Court, over the course of the 1970s and 80s, extended that to say that if the parties agreed in their collective bargaining agreement that every dispute of any kind, whether it arose from the agreement or from a statute, was subject to arbitration, that also could be enforced. The party that refused to go to arbitration could be ordered by a federal court in an injunction to go to arbitration. They even said, in one case in the 1960s, that if a dispute was subject to arbitration, the union could not strike about it. So the court, if the union did strike about a dispute that was subject to arbitration, the court could issue an injunction against the strike. And of course, the Norris-LaGuardia Act was intended to forbid federal courts from issuing injunctions against strikes. So now that was another exception to the ban on injunctions in labor disputes. Well, an interesting phenomenon. Organized labor reached its height in the private sector, that is, businesses, nonprofit organizations, non-governmental organizations, in the mid-1950s. At its height, the union movement had organized almost a third of the employees in the private sector. But then it started to decline. Today, it's under 10% of the private sector. But a contrary phenomenon was occurring. The federal government and the states began to pass statutes authorizing public sector collective bargaining, which had previously been almost non-existent, except for a few areas in the country. And the proportion of the public sector that was organized started to grow tremendously. And the public sector is not covered by the National Labor Relations Act. It's not covered by federal law except for federal employees. State and local employees, teachers, firefighters, police, the vast army of bureaucrats in the various agencies and departments of state and local governments, employees of public hospitals, millions and millions of people who were not covered by the National Labor Relations Act were suddenly covered by state collective bargaining statutes. Here in New York, we have statutes authorizing bargaining by public employees. The main one is the Taylor Law, which governs collective bargaining, for example, between the Teachers Union and the Board of Education in New York. And what about situations where public employees are now in unions, and the unions want to negotiate a provision that everyone in the unit, like everyone in a particular school or everyone in a particular public agency, must be a member of the union. The same question arises of individual rights that was recognized by the Supreme Court in the 1950s in the private sector, where they said that there can be agreements requiring people to support the union financially for its collective bargaining activities, but not for its political activities. This became an issue in the public sector. And the second case that I was going to talk about, but I'm probably not going to have time to talk about, deals with that, with whether public employees can be required to support a union as a condition of being employed. And so the Supreme Court, reversing a 25-year-old precedent, ruled on June 27th that that violates the First Amendment to require public employees to provide financial support to a union. So the public sector union movement now is trying to figure out how they're going to finance their activities when they can't negotiate these what are called fair share agreements or agency fee agreements. But turning to the other issue, arbitration, as the union penetration in the private sector declined, there were more and more big companies which perhaps in the 40s and 50s they would have been unionized. Now they were not unionized, but the employers thought, this arbitration business, this is a good idea. We should have arbitration even though we don't have a union. We should have a requirement that our employees agree to arbitrate any disputes they have with us for the simple reason that it keeps us out of court. Court is expensive. Arbitration is relatively inexpensive. Court proceedings take years. With arbitration, you line up an arbitrator, they come in a few months, they decide the case in a few months, it's all over. So employers, starting in the 1970s, 1980s, many employers, especially in large companies, began to require employees to sign agreements that they would arbitrate any dispute they had with the company. And originally, this was focused primarily on disputes about whether the company was following its own rules and making decisions about promotions and things of that sort. But gradually, it also spread to statutory claims against the employer, because another phenomenon of American law in the mid-1950s and going forward was increasing legislation dealing with workplace issues that had previously been unregulated by the federal government, left totally up to states, or totally unregulated in any way. The earliest of these, actually dating back to the New Deal years, was the Fair Labor Standards Act, which established the federal minimum wage and overtime requirements. But there are other statutes that came in during the 1950s and 60s and 70s. We had the Civil Rights Act of 1964, prohibiting employment discrimination. We had the Occupational Safety and Health Act, setting workplace safety standards. We had the Pension Reform Act, known by its initials as ERISA, governing employee benefit plans. So all of a sudden, employees, whether they were in unionized workplaces or non-union workplaces, employees had a lot of statutory rights, and states were also passing similar statutes. We have in New York a state human rights law, for example. And employers wanted to expand these arbitration agreements to say that whether your claim against the company is based on a contract claim or a statutory claim, you have to arbitrate. And in the late 80s and into the 90s, the Supreme Court began to decide cases holding that federal courts could issue injunctions to enforce those agreements, requiring employees to arbitrate rather than go to court about their statutory claims against their employers. So now things get really interesting, because many companies were seizing upon arbitration as a way to avoid litigation, not just about employment disputes, but about disputes with their customers, consumer disputes. And in fact, unless you're a glutton for punishment, you probably haven't done this, but if you still have a copy of one of those forms that you get from your bank or from your credit card company setting out all the terms and conditions governing your agreement, these days you'll notice that there's a provision in there obligating you to arbitrate any dispute you have with them. You can't sue them. If you sue them, they can get an injunction ordering you to arbitrate, which is a private dispute resolution process outside the courts, where consumers are generally seen as not being in a very favorable position in arbitration. Partly because the companies they're suing are repeat players, and they know who the arbitrators are, and they know the process. They set it up unilaterally. And you, if you want a credit card with this company, you have to take the agreement. You can't bargain about it. It's called the contract of adhesion. You have to accept the terms that are proposed to you. That's the basis on which they do business. And they got those enforced in the courts, those consumer contracts. And because one of the things that companies hate is class action litigation. thousands of people suing them. Each individual person has a small claim that isn't worth pursuing because litigation is so expensive. But if you accumulate the claims of hundreds of thousands of people that are common or similar in a class action, then it makes sense. The cost of litigation is spread over all those claims. So they started to put into those provisions that you have in your standard form contract with your bank or your credit card company, or when you rent a car, or just about anything you do that has a standard form contract these days. It also forbids class action lawsuits. It says if you have a claim, you can only bring it in arbitration and only as an individual. And the Supreme Court, relatively recently, issued some decisions upholding those. Okay, so now the employers get the bright idea to ban class actions in employment contracts as well. Not only class actions in court, but class actions in arbitration. And that's the big case that was decided on May 21st. And the case involved a fellow named Stephen Morris. That's one of three cases that was actually combined, but this is the one that Justice Gorsuch describes in his opinion for the court. So Stephen Morris was a junior accountant at Ernst & Young, big accounting firm. He was there for a few years, and they didn't pay overtime to their junior accountants. They classified them as professionals, and professionals are exempt from overtime if they make a certain salary. And to be classified as a professional, you have to have advanced education, and your job has to involve a certain level of intellectual discipline and stuff that classifies you as professional as opposed to just rank and file everyday worker. And under the Fair Labor Standards Act, professionals can be paid a salary and are not required to be paid overtime. In fact, usually they're not paid on an hourly basis at all. But Mr. Morris believed that junior accountants did not qualify as professionals and should have gotten overtime. So after he left Ernst & Young, he filed a lawsuit, and he made it a class action lawsuit on behalf of the hundreds and hundreds of junior accountants employed around the country by Ernst & Young, which is a big national firm, for unpaid overtime. And the Fair Labor Standards Act authorizes individuals to file class action lawsuits for unpaid wages, whether it's they didn't get the minimum wage, they didn't get overtime, because both of them are covered by the Fair Labor Standards Act, or because an employer misclassified them as an independent contractor, because the Fair Labor Standards Act only applies to employees. So these misclassifications and failure to pay is widespread in the country. In fact, Justice Ginsburg, in her dissenting opinion in this case that I'm talking about, cites a study of just the cities of LA, Chicago, and New York. In the course of a year, it is estimated that workers in those cities have potential claims for $3 billion in unpaid wages, either because they weren't paid at least the minimum, or they were misclassified as exempt, or they were misclassified as independent contractors. All right, Ernst & Young required all its employees to sign an arbitration agreement as a condition of employment that absolutely prohibits class actions. But you might ask, if you remember all I was talking about the National Labor Relations Act, that the National Labor Relations Act says that it is an unfair labor practice for an employer to interfere with concerted activity by employees for mutual aid or protection. Doesn't a class action lawsuit for unpaid wages sound like concerted activity? It's about bringing the claims of hundreds, perhaps thousands of junior accountants who worked for Ernst & Young, seeking their overtime that they're entitled to if a court decides that they were wrongly classified as exempt professionals. And that's a question that hasn't been decided yet in this case. That's a question of fact that has to be decided. Is it going to be decided by a court or an arbitrator? Is it going to be decided in a class action? Well, what happened is Ernst & Young filed a motion with the court to dismiss the case and order Mr. Morris to submit his dispute to individual arbitration of just his claim. And the trial court granted the motion. And Morris appealed to the Court of Appeals, and the Court of Appeals said, well, hold on a minute. What about the National Labor Relations Act? Hasn't the NLRB ruled in a case similar to this that it violates Section 8, the unfair labor practice section, for an employer to require employees to agree that they will not engage in concerted activity such as a class action lawsuit for mutual aid or protection. Remember, we're not talking with Ernst & Young and with Mr. Morris about a unionized workplace where he could file a grievance and a union would pursue it. And the union undoubtedly would pursue it on behalf of all the people who claim to be misclassified, not just Mr. Morris, because that's the way union contracts work. But this is a non-union company. This is a non-union company. And so the argument goes, under the National Labor Relations Act, this would be an unfair labor practice, therefore, this should be an unenforceable arbitration restriction. And the Ninth Circuit agreed with that, relying in part on a decision by the NLRB from 2012, D.R. Horton case. And you might ask, why did the National Labor Relations Board only get to this issue in 2012? Well, it's because employers only started putting in these class action waiver provisions in their arbitration agreements within the past few years after the Supreme Court upheld them in consumer cases. This is getting very complicated in the weeds, but you know, the result of this case, which was decided by the Supreme Court by a vote of 5-4, Justice Gorsuch writing for the court, Justice Ginsburg dissenting, all of the appointees of Republican presidents on the court are in the majority. All the appointees of Democratic presidents on the court are dissenting. This is what our Supreme Court's going to look like, perhaps for a generation, given the current politics of the situation. So Justice Gorsuch says, well, we have another statute we have to take into account here, he says. The Federal Arbitration Act, which was passed in 1925, and which says that federal courts shall enforce agreements to arbitrate disputes, unless there is some general contract law principle that makes that agreement unenforceable, like it was procured by fraud, for example, or that someone signed under duress, or it violates a public policy. Violates a public policy. What about the National Labor Relations Act? Well, this is where Justice Gorsuch gives us an opinion that restricts the Section 7 concerted activity rights of employees. He says that that should be interpreted to apply to forming unions, engaging in collective bargaining, and doing stuff in the workplace, concerted activity in the workplace. He said it shouldn't be interpreted to extend to going outside the workplace and filing a lawsuit in court. That shouldn't be considered part of the concerted activities protected by the National Labor Relations Act, thereby implicitly overruling the NLRB's decision in the D.R. Horton case from a few years ago, which was probably going to be reversed or overruled by the NLRB in the next few years, now that President Trump has started getting his appointees to the NLRB. Because remember, the NLRB in 2012 had a majority of Democratic board members, and now it's going to have a majority of Republican board members. But they won't even have to overrule or reverse D.R. Horton because the Supreme Court has implicitly done it for them in this case, where they have restricted the meaning of Section 7, Epic Systems against Lewis. The reason that isn't Ernst & Young versus Morris is because this was a consolidation of 3 cases arising from 3 different federal appeals courts. And the first one that gets filed is the one that's the name on the Supreme Court decision. So Ernst & Young and Morris was the second one that got filed. So it's not the name on the Supreme Court decision. Well, Justice Ginsburg really went to town in her dissent. And part of her dissent focuses on the legislative history of the Federal Arbitration Act, which Justice Gorsuch's opinion totally ignores, doesn't even mention. In 1925, labor arbitration was almost non-existent. Congress wasn't thinking about labor arbitration. The reason for the Federal Arbitration Act was that federal courts generally refused to enforce arbitration agreements. They usually held that they were not contractually binding, or there was no consideration for them, or there were other defects in them. And the business community prevailed upon Congress to pass a law authorizing federal courts to enforce arbitration agreements, which they wanted to use to avoid having to go to court when they sued each other. Congress was concerned with what is called commercial arbitration of disputes between companies. And organized labor at the time, the American Federation of Labor, raised the alarm. They said, we're worried about courts issuing injunctions in labor disputes because employers will force people to sign arbitration agreements or something. And the Secretary of Commerce at the time, Herbert Hoover, who later became president, he was the Secretary of Commerce, he suggested a solution. He said, we'll put a provision in the statute that says it doesn't apply to employment agreements. And so there is a provision in the Federal Arbitration Act, Section 1, which says that this act shall not be interpreted to apply to employment agreements. Well, what is the agreement between Ernst & Young and Mr. Morris but an employment agreement? Well, Justice Gorsuch totally ignores that. Justice Ginsburg says, just a minute, the Federal Arbitration Act should not be interpreted to apply to any employment agreement. Congress said so. But she only had 4 votes. It takes 5 votes to decide a Supreme Court case. So now we are working in a world where employees who have wage claims under the Fair Labor Standards Act, whose employers require them to sign these arbitration agreements, may only arbitrate as individuals. Justice Ginsburg pointed out that in these cases, the employees are not claiming that they shouldn't have to arbitrate. They're saying they should be able to do class action arbitrations, and they do exist. There have been cases where arbitrators have decided things on a class action basis involving a particular defendant. So it could be done. But as she pointed out, because she has been in the dissent all along, she's been on the court throughout this period where it's been expanding the enforcement of arbitration agreements. She says the court went wrong long ago in its interpretation of the Federal Arbitration Act. And it shouldn't have authorized employers to require their employees to bring their statutory claims into private arbitration. Those statutory claims involve a public right derived from a statute. They should be done in court. But this is the dispute, and this is how it's been resolved. So it's sort of bad news on Labor Day weekend for employees. This is going to undermine drastically the enforcement of the Fair Labor Standards Act, which is one of the most widely flouted statutes in America, as you saw, that study. And in fact, there was a prior case involving Ernst & Young that Justice Ginsburg cited in her dissent, which said that someone's cost of doing a private arbitration proceeding under the Ernst & Young arbitration program came to $200,000 for a $2,000 claim. Now, under the Fair Labor Standards Act, courts can award attorney's fees to winning parties who sue for their unpaid wages. But of course, this is in arbitration. Question whether an arbitrator is going to order a company to pay $200,000 in litigation expenses to somebody who prevailed on a $2,000 unpaid overtime claim. Unlikely. That arbitrator will never be selected again by any company to arbitrate a dispute. So, this means that the Fair Labor Standards Act, which is already drastically under-enforced, is going to be even more under-enforced because individuals who work for big companies will not be able to bring class actions, even in arbitration, to enforce their claims. I think the public tends to be marginally aware at best of what's going on in the Supreme Court. And when newspaper articles appear the next day after an opinion, they'll tell you what the holding was, and they may say something about why it's important or how it may affect things, but they rarely give you the whole background. What the statutes were and when they were passed and what they were intended to accomplish, and how the current decision, according to the dissenters, totally distorts the statute and undermines public policy as a result. And this is one of the reasons why elections matter so much, because elections decide who appoints these judges and who votes to confirm them. And we've got elections coming up. We'll see what happens. But at the present time, as a result of the last presidential election, the various federal agencies like the National Labor Relations Board, the Equal Employment Opportunity Commission, the Occupational Safety, Health and Review Commission, all of the federal departments are now being run by appointees of the Trump administration. And they've already started at the NLRB, and it's well underway, reversing decisions by the board from the Obama administration, changing the direction of the law affecting labor management relations. One big issue, and just to close on this, one big issue that they've decided to reconsider, under the board with the Democratic majority during the Obama administration, there was a ruling that employees should be entitled to use their company's email system to communicate with each other about their common concerns about the workplace, to talk about wages and things of that sort, or even union activities. That the email system being made available generally to employees to use, they should be able to use it for this purpose. The NLRB has now sent out a notice that in a pending case they're going to reconsider that ruling. And they've asked people to submit briefs who have an interest in the issue, what the argument should be. But employers are arguing that email system at the company belongs to us, we shouldn't be required to allow employees to use it for union activities. Well, the NLRB in its prior decision said, what about the right of the employees to engage in concerted activity for mutual aid and protection? Hard to do it if you can't talk to each other. And the main way employees communicate with each other these days is through company email. So that's an issue that's going to be decided. Many other issues to be decided. So stay tuned. On the end of September, the last week in September, the court has what they call their long conference, where they meet and decide which cases they're going to hear in the coming year from all the petitions that have accumulated over the past several months while they were on recess. And usually in the newspapers that weekend or on Monday morning, October 1st, when they hold their first open session of the term, there is an announcement of a long list of new cases. So pay attention to what the Supreme Court is going to be looking at. And to the extent you can, try to follow what's happening and inform yourself about what these judges are doing. Okay, I'm happy to take some questions. If people have questions they want to ask.
A little bit of time, so
A little bit of time for
two or three questions.
Okay,
Ken?
you were first. Well, the Fair Labor Standards Act was passed in the 1930s, just a few years after the Wagner Act, I think 36 or 37.
And the Taylor Act?
Taylor Act is from the 60s, I believe. Right, so public sector bargaining really got started in a big way in this country in the 1960s.
Yeah.
Yes.
Question, is there anything that the state or Congress can do to change any of that ruling of the Supreme Court?
Well, the Supreme Court's ruling is interpreting federal statutes, and federal statutes take priority over state and local laws. So it's questionable whether the states can do anything. I know Governor Cuomo has said on the issue of the union dues, he said he's going to try to come up with some kind of solution so that the public sector unions in New York State don't become drastically underfunded. In her dissent in the union dues case, Justice Kagan, writing once again for the 4 Democratic appointees on the Supreme Court, pointed out that the whole public sector union situation has relied for years on the ruling from 1991, I believe it is, Abood versus Detroit Board of Education, where the Supreme Court upheld a requirement that employees provide financial support to the union. And she said in at least 22 states, there's legislation that incorporates this understanding and authorizes the negotiation of these fair share agreements. And she chides the majority for failing to look to that reliance as a reason to stick with the old decision. But she also explains why the old decision was correct and the new decision is wrong.
How was Ronald Reagan able to fire all these striking air traffic controllers?
Okay, that was because those were public employees, and their right to strike was not protected by any statute. See, the Wagner Act in 1935 has a provision saying nothing in this statute shall be interpreted to impede or prohibit the right to strike, but that was for private sector employees. Government employees don't have a legal right to strike, either under the Federal Labor Relations Act or under the laws of almost every state. There are only a handful of states that allow certain kinds of employees to strike. And also, of course, there was a statutory prohibition. I think there may have been a prohibition also in the collective bargaining agreement between their union and the government. But even if there wasn't, there are statutes. And the theory is that public employees are providing vital services whose interruption would be harmful to the public welfare, and therefore they shouldn't be allowed to strike. And in exchange for that, in many states, the public employment relations laws authorize arbitration to solve disputes in place of strikes, including arbitration over new contract terms. And the parties are bound to adopt the arbitrator's solution to their negotiation deadlock. Because, I mean, if the police strike, here we have a city with no police protection. What if the fire department strikes? We're going to let buildings just burn down because the firemen are on strike? But what about the teachers? You know, what about the teachers? Should teachers be allowed to strike? Well, the Taylor law says no. That they can be fined, they can lose their jobs, you know, because if school is interrupted, the educational process is interrupted, and not only that, all these parents all over the city will have kids at home during the day when the parents have to be working, you know. So if the teachers go on strike, there's lots of arguments why they shouldn't be striking.
One last question. When President Obama nominated Garland, and Congress didn't take it up, there was an op-ed article in the New York Times from a Harvard professor, and he said that Obama should have said, since Congress doesn't want to do their job, de facto he is the next Supreme Court justice. Sure,
Well,
do you think he should take that?
Well, unfortunately, the Senate had set it up in such a way that he couldn't do that. There is a provision in the Constitution that says when the Senate is in recess, when Congress is in recess, the President can make recess appointments. And in fact, Earl Warren was appointed Chief Justice by President Eisenhower on a recess appointment because Chief Justice Vinson died of a heart attack suddenly during the summer, and they didn't want the court to be shorthanded, and the Senate wasn't around, so Eisenhower appointed Earl Warren. And on a recess appointment, he could serve until the end of the next session of the Senate. But the Senate then confirmed him. But they've set it up that the Senate is never in recess.
But that wasn't, I think, his point. The point was, since they were not doing their responsibility, they had forfeited.
Yeah, but he didn't have any authority under the Constitution to do that. The Constitution says that the President may nominate, and upon confirmation by the Senate, appoint. He needs the Senate's vote before he can appoint. And saying that Obama could have just appointed Merrick Garland, I felt very wounded by that because he was a law school classmate of mine, Merrick Garland. I thought it would have been wonderful to have a law school classmate as Chief Justice of the United States. And he's a really bright person who would have done a great job. But the President can't act alone. I mean, the op-ed was undoubtedly well-intentioned, but I disagree with it. If there was a recess for any, and the Supreme Court in a recent case has said the recess has to be, it's not just a few minutes between one session of the Senate and another, it has to be for several days. That the purpose of the recess appointment clause, which was included in the original Constitution, was in those days with transportation and communications and everything, when Congress wasn't around, to get them all together would take a long time. And so that's why we needed the recess appointment, because there would be vacancies and positions that had to be filled. But today, it's almost an anachronism, and the Senate has reduced it to a total non-entity, that provision, because they have decided to stay continuously in session for each term of the Senate to avoid the President making recess appointments. And so you can't make them anymore.
That's because Obama made a lot of recess anyways.
Well, he made some, and as a result of the Supreme Court decision, they invalidated them because he was capitalizing on them taking a brief recess of a few days to appoint people to the NLRB and the EEOC and all these agencies. And in fact, in one case, the Supreme Court said the NLRB cannot decide cases unless they have a quorum, which means out of the 5 members, they need to have 3 that have been confirmed by the Senate. And it had dropped down to 2. And they tried to delegate their decision-making authority to 3-member panels, of which one was a ghost, because they said 2 can decide a case in a 3-member panel. But the Supreme Court said no. Okay, I guess we've run over, so thank you. I'll hang around if you have some more questions.
Okay, so I have a description of the charity I'm going to use. Okay, every Sunday we share our collection with a nonprofit organization that shares our values, which gives us an opportunity